episode 41.
Hey, this is Josh Elledge from upendpr.com and savingsangel.com, and I've been in the media over 1,500 times, but there's no finer place I've ever been than on the Small Business Puzzle podcast, which you're listening to right now.
Struggling to get your business online? You've come to the right place. Welcome to the Small Business Puzzle podcast. Now, here's your hosts, Michael and Teresa Blaze.
Welcome to the Small Business Puzzle podcast. I'm Michael, and I'm here with my better half, the love of my life, my wife, Teresa.
Hello, everybody. I hope everybody's doing well. I know it's been a while since we've gotten an episode out. Eventually we're going to get back to where we're being consistent again. In fact, that's going to be one of our goals for 2018. Just saying.
Life keeps getting in the way. Anyway, but so much has happened. It's been crazy. We've been doing some interviews, and we've got some pretty awesome interviews to share with you. So why don't we go ahead and let's talk about the interview we've got today.
And who do we have today?
His name is Bobby Klinck. He is an intellectual property attorney, but he's not your typical lawyer. And we found this out. He went to Harvard Law School and worked at some of the most prestigious firms in the country. But when you look at the big whiteboard in his office, you'll see you won't see much about the law. His whiteboard is filled with tasks related to platform building, inbound marketing, and sales funnels. Bobby is a full-fledged online entrepreneur whose area of expertise is the law.
Here's the thing. We've done a lot of lawyer interviews, okay? And a lot of interviews where we've had to really struggle to get content, But this guy when he starts referring to things he could do as lawyer repellent, it's going to be a fun interview. I mean, come on. This guy was
And we learned a lot. We learned a lot about more about intellectual property than I ever knew before.
So, guys, seriously, check this out. Hey, give us some feedback. What kind of interviews do you want us to get for you? We really would like to know.
Or do you want us to go back to doing content?
Yeah, we would really like to know. We want to make this something that you guys want, and especially going forward in 2018, we want this to be about what you guys want. We enjoy doing it, and we want to hear from you. So, Mike, give them that email, please.
It would be Michael at sbppodcast.com or Teresa at sbppodcast.com. If you want to speak it out, you want to get it off your chest, you can go to our homepage and use our SpeakPipe tool. And you can record your voice, and we'll get that. And we will probably include it on the show. So make sure you include your website when you do your recording.
Oh, that, here's our interview.
Here's Bobby. So, Bobby, welcome to the Small Business Puzzle podcast.
Thanks for having me. I'm excited to be here.
And we're glad to have you here.
So, I have a starting question, if I could.
Okay, great.
Okay. What is the biggest legal mistake that most business owners make?
If I had to say one, what I would say is that most small business owners and entrepreneurs rely way too much on handshake deals or, kind of my word is my bond type of things, and don't get their critical agreements in writing. Mm-hmm. I like to say if it's not in writing, it didn't happen. And I also like to tell people that often you don't need sometimes you're not going to need a written agreement, but what you should think of a written agreement as for any one of these key agreements is lawyer repellent. That way, if you have written agreements, you don't have, you don't have to come to someone like me because you're not going to have fights down the line. Right. And so that's what I would suggest to people is they need to get their key agreements in writing. I mean, there's some fundamental ones that people don't do, including people who have an LLC or who are working together as co-owners, but they don't have a basic ownership agreement, setting out who owns what the responsibilities are, and more importantly, what happens if you disagree. Because as much as you like your co-owner now, I promise there are going to be times you're going to not agree with them, and you need to have a way to resolve those disputes so it doesn't destroy your business. So I mean, that's a critical one. You also need to have agreements with any of your clients, and those should be in writing. And as an IP attorney, one of the things that I know that you need that most people have no idea you need is you need agreements from if there's more than one founder, you need it from your founders, but also from all employees and all independent contractors, transferring all intellectual property to the company, because that can only be done by a written agreement. And I have faced a lot of circumstances where, a decade later, on behalf of a client, I'm trying to track down a former employee who may not have left the company on good terms and try to get that employee or former employee to sign a document transferring rights that they really don't want to be talking to me. And so you need to get that stuff done at the outset.
That makes sense. So it definitely something that you want to pre-plan. And we've experienced our share of that. I remember one particular so-called client that we were working with, and they were a credit repair company, and oh
boy,
that got ugly really quick. It's a miracle we didn't get sued.
Yeah, well, and some relationships are going to end badly no matter what. But if you don't have client agreements, I like to think that not having the agreement is likely to actually destroy the relationship. And the reason why is, look, let's be honest, people have different memories of things.
This is true.
A year from now, each party is probably going to have a memory that tends to favor themselves. And it's not because they're bad people or doing anything wrong. That's just the way human memories work. And so if you have no written agreement, I'm going to say, well, the agreement was X, and the other person can say, no, the agreement was Y. And then you're going to fight about it. And either you're not going to come to agreement then, or you are, but one party's going to feel like they caved and they're giving in, and it will just sour the relationship. Whereas if you had a written agreement, guess what? It'd be very simple. Well, I think it's X, I think it's Y. Well, hey, let's look at the agreement and see what it says. And then, whoever's right is right and whoever's wrong is wrong. And there's no fighting about it. So
that makes a lot of sense.
Now, how does intellectual property play into the social media space? Because, you're talking about a complete can of worms when you're dealing in that.
Well, what I would say is, and this is something that a lot of people don't think about or don't get, and let me start by defining intellectual property for people, because it's this term that lawyers have a sense of what it means, but I'm going to put it in a non-lawyer world. To me, intellectual property is anything you can own that you can't hold in your hand and is not a piece of dirt. So it's an idea, it's a concept, it's a brand, it's these kind of intangible assets. And so everything you're doing online is wrapped up with intellectual property. If you're building an online platform or an online brand or thought leadership, 90 to 95% of what you're doing is creating intellectual property of one sort or another. The most common examples that people can think about are trademarks. And so a trademark is a word, a phrase, or a logo that defines the source of a good or service. So it basically says who's making or providing this product or service. Let's think of
let me ask you this question, because this is something that, we've struggled with ourselves. When is the right time? When should you trademark your product or your brand name?
Well, what I would say is the actual act of trademarking, and by that I assume you mean registering a trademark,
Right.
is not the most important decision.
Okay.
Because you get rights automatically by using it. So as soon as you start using a name, a logo, a slogan out in commerce, which just basically means anything you're doing online is in commerce, you get protection.
Okay.
The bigger mistake on trademarks and what people don't do is what I call the due diligence, which is, basically just fancy lawyer speak for kind of doing your homework and making sure you're not going to step on someone else's toes. And
how do you do that? How do you go about doing that?
Well, basically what you're trying to do is make sure that no one else has a trademark. And the problem is, look, it's not a simple process because trademark rights come up automatically. And so because they come up automatically, there's not a single place where you can go to find everything. But what you have to do is basically you have to search through the U.S. Patent and Trademark Office's registered trademark system. It's called the TESS system. Then you need to just do some basic due diligence. Go on Google, type in the word, and see if anything comes up, and go multiple pages deep. And then the last piece I like to say is go onto a service like Namebind, which will search, see, hey, is the domain available and are social media handles available, or has someone already taken it?
Okay.
If all that comes up clean, you should be good. The problem is what happens if you find that someone already has, let's say someone already has the Facebook name, or someone already has the Twitter handle or something like that. Then you have a more difficult situation. And what I would tell you candidly is unless this is a name that is so good, you probably should just come up with a new name. Because if you find that someone else is using it, you're going to have to come and pay someone like me money to give you an opinion on whether you can use it. And that opinion is going to be worth about as much as the paper is written on. I mean, look, I can give you my best guess, but the fact is that it's not a guarantee. If I say, oh yeah, you're fine, it's not a guarantee. And the thing I like to say is for a small business, quite honestly, what you're trying to do with legal issues is risk management and avoid risks and avoid finding yourself having to hire a lawyer later. So again, lawyer repellent is what you're looking for.
Right.
And so you want to avoid any name that might get close.
So especially nowadays, as you're looking at, because I know, a lot of times you have to read through Facebook's terms of service, and of course that's like pulling teeth.
I love it. What are you talking about?
You would anyway.
We know who to call next time we have to read one of these crazy things.
Yes. But like half the time you're kind of going, and what a lot of people do not realize, and a lot of times what a lot of people don't realize, and one of the things that I caution everybody is when you set up your own Facebook page, Twitter page, whatever, you don't own the content on that site at that point.
Well, actually,
am I wrong?
It's not entirely true. That was an issue in the old days. In the old days, Facebook had the terms of service that said, yeah, you were giving all your rights to them. I'm not 100% sure on this. I'm about 95% sure that now that's not the case. What you give is you give Facebook the unfettered right to have, or an unfettered license. They have a complete license to do with it whatever they want, but you still own the information. Is the way that it's worked. And the reason why was when the language like what you're saying first appeared in their terms of service, or when someone first discovered it, a lot of people went crazy because, again, and I don't think people should care that much if their Facebook posts belong to Facebook, right? But the issue was everybody was posting pictures, and under the terms that you're right, that used to be there, Facebook then owned those pictures. And so you no longer had a right to post that picture anywhere else. So they did change that. I'm, like I said, 95% sure on that. The bigger issue that's happening now, and what's interesting, is there's these questions for some people used to think that as soon as you posted something on Facebook, then it became what's called public domain, which meant they could just copy it and use it for their own purpose. And it happened in kind of I say famous, it's famous among IP lawyers, but famous case where Getty Images of all places, which is a company that really will go after people for copying and pasting their images, actually got an image that someone had posted on Twitter, a photojournalist, and then put it in their library for people to buy. And their theory was, hey, you put it out there so we can use it. And the court ruled, no, that's not the case. Putting it on Twitter doesn't give someone else the right to, what I like to say is right-click save as, and then use it for their own purposes.
Right. Yeah, that's the crazy thing about about marketing and social media, marketing in general and social media in particular, is the fact that it's all about sharing that good content.
Mm-hmm.
It's a short line to cross if you think about it, because if you're just sharing it, you're probably okay. But if you try to use it in some of your other marketing or on your website or something like that, then you're taking the risk of somebody sending you a cease and desist.
Well, yeah. Well, the line that what I'll tell you is if you go and use it kind of within the parameters of the particular website. So again, on Twitter, if I were to retweet your tweet that had an image, there's no problem there. Right. If I share your Facebook post, again, no problem there. The problem is when I go and try to take something from your social media, and again, like I say, I think of it as the right click save as problem. If I go to one of your images, right click save as, and then want to use that somewhere else, that's when you can't do that, because that is basically taking a copyrighted image for a purpose which you're not supposed to be taking it.
So let me ask you this, because what I have seen in my meanderings online, a lot of people will take and embed tweets into their website of other people. So where it's actually still on Twitter, but they live framed it into their website. If we're talking about something, so does that cross the line of intellectual property and all that fun?
No, I think, again, I assume what you're talking about is where you have a widget on your website which is just showing you tweets.
Yes, sir.
That's not the problem. What I'm talking about is, and again, it's normally going to come up in the context of like a photojournalist, right? So let's say that some photographer, tweets out some images. The problem isn't if you copy if the whole tweet goes somewhere. The problem is if you go and grab the image and then want to use that image. That's where you're running in the lines. Again, if you are, kind of just using the native social media site and providing it, you can do that. Now, I'll tell you, there are some disreputable people out there. One example are folks who, and again, some people I guess wouldn't have a problem with people doing this, but they're photographers or artists who put their images on various sites where they are giving a free license. Say anyone can use this, but you have to give attribution, meaning you have to tell them who it's from. And there's nothing wrong with that. But some of these people will then, they know that a lot of people aren't going to realize that, are going to use the image without attribution. And then they send them a letter that's demanding, tons of money. It's not saying, hey, you didn't add the attribution. Can you add attribution to that? No, they're demanding, hundreds or thousands of dollars. And for the life of me, I look at it and say, well, you're giving it away for free if somebody puts your name on it. How can you possibly say it's worth, $100 or $1,000 or anything like that? But people will do that. So you have to be careful with images when you're grabbing images anywhere. But the biggest problem is people just, and it's not on social media so much. What I've heard a lot of people say they do is they go to Google Images and they type in whatever they're looking for and then just grab an image off Google Images. Well, that you definitely can't do. Because Google Images is pulling images from all kinds of places, websites, etc., and you definitely don't have a license or right to use those images just because you found it on Google Images.
Well, hang on one second, because I know that in search there is a capability of searching for images that you can use.
Yeah.
So I mean, to me, I mean, are you okay doing that as long as you're using it with the
Proper
license that they're giving you?
Yeah, so the trick is to find a place that offers images you can use. And so there's a couple of different websites that I use. I use Pexels, which is Pexels. And then there's Pixabay. But again, there's a lot of other ones you can find. What you're looking for, though, just let me give you kind of
a really neat one that I want to mention real quick.
Yeah,
have you ever heard of Unsplash?
I have. I have, and I've gone there. I mean, there's so many different ones out there.
Man, the images are amazing.
Okay, well, I'm going to put that on my list then. But let me give you the trifecta. When you're looking for an image, what you want is you want it to say that the license is royalty free. And what that means is it means that you're not going to have to pay some royalty if 1 million people look at it or 100,000 or anything like that. You don't have to worry about anything like that. It needs to say that it's okay for commercial use, and be careful on that. So a lot of not the picture sites so much, but a lot of these apps that put, where you can do a picture or an image with a quote on top of it. Actually, when you read their terms, they say they're only for individual use, not commercial use. So be careful on that. And the third is you want no attribution required. And if you have those three things, you can, once you have the image, you can use it wherever, whenever, without having to say who created it and without having to worry about anything else. So you can go to a free site. Then there are sites that'll charge you like a membership fee for a year or something you can go to.
Right.
And again, those will give you the same options. And then you have the places where you pay per image.
And that gets expensive quick.
It does. And I got to be honest, when I first started my own law firm, I didn't know any better. And so I would go to Shutterstock and I would basically get all my images there. And I don't remember, I think it's like $5 to $10 an image.
Right.
But, if you're putting out a regular amount of content, that does get expensive.
Yeah.
And so, those are your options generally.
And we were with a really neat program called Dollar Photo Club. It was great because we got like 10 images a month for $10, which is just a fantastic price. And then they sold out to Adobe, and Adobe, we went from paying $10 a month to $30 a month for the same amount of images.
Yep.
And then when I tried to cancel it, well, we're not going to go there. But it got ugly. So, I will not recommend Adobe stock photos to anybody, even though they're great images, beautiful, beautiful pictures, and a number of different markets and so on and so forth. I mean, I can't think of one search that I did that I didn't find at least one image that I could use, but I won't recommend them because of their business practices.
Yeah.
But yeah, I mean, it does. These images get expensive really, really quick.
Yeah, I mean, what I tend to do for my now is I tend to look at the free sites first. Then I'm a member. It used to be Graphic Stock. Now it's Story Blocks, which they have images, but they also have music and I think stock video as well. But so that's a membership site, which I have. I'll look there. And if all else fails, I might go to Shutterstock and pay $5 or $10 for an image if I really need one for a particular.
And how much is the Storyblocks membership that you're paying now?
It's $99 a year is what I paid, but it's just for, so you only get images. Each one is separate. So there's images, and then you'd have to do a different one for the audio and a different one for the video.
Okay.
That's where it gets expensive. Okay.
Yeah.
Yep.
And the same thing applies to music, and the same thing applies to video.
I mean,
and music, music I hear on podcasts all the time. I will go. I listen. Look, I appear on podcasts. I'm actually launching my own podcast in a couple of months.
Awesome.
But so I also just listen to podcasts all the time, and I'll listen to a podcast, and I'm like, and again, you never know the listener, but I'm like, I think this is a pretty small podcast, and they're playing a top 10 hit, that's the kind of music that would cost you, thousands of dollars to license. I think they're just
Let's
doing
put it this way. We've
permission.
looked in because we wanted to launch a podcast to play Christian rock music and stuff like that. And I mean, we used to run a radio station long time ago, and that was fine. We can handle the licensing for that, but the licensing to do the actual podcasting and cover your costs, it was like $700 when I looked at it. It was like $700 per download, and I'm like, never mind. We're not doing that.
Yeah, that's a lot. I mean, I've heard people, again, I would never go down this route, but I've heard people say that it was, a few $1,000s for like a 5-year license for a song or something. But I don't see how it's worth it personally.
No, it's really not, unless you can get a hold of the artist and, you have some connection with the artist. Maybe you can get the rights for it, but most cases. Can you address, since we're on the subject of music, can you address fair use?
Well, fair use is a concept that what I'll say is for music, I don't think you should think it applies. The doctrine of fair use applies to copyrights, and it says that you can make, and again, it's a pretty broad concept, a fair use of a copyrighted work without getting in trouble. Now, what does that mean? Well, so let me give you some classic examples that are fair use. Doing a review. So if you do a review of music, you have to be able to play it. Doing, a movie review, that will generally be done. Doing a review of a book, you're obviously going to put parts of the book. Satire is another one that can be protected. But the problem is the line isn't always clear. And let me talk about something that would never be allowed. Using a song as your intro music or outro music or bump music on a podcast, that is not a fair use. It just isn't. And fair use, there's not some exception where, if I only use 5 seconds or 7 seconds or some limited period of time, that's not infringement. And I hear that a lot. It's not the case. Literally, if it's any recognizable portion of a copyrighted work, it could be infringement. Now,
here's a question then. Could you, because I actually listened to a podcast where they will sometimes play clips of a song, but they're doing it in order to
that would probably win a fair use argument. If that's if that's the purpose. But let me give you the other example where, and again, what I would say is if you want to rely on fair use, you really need to meet with a lawyer and have them look at your particular circumstance. Okay. And that's why I'm saying it's an expensive proposition in my view. And I'm not sure that, for most entrepreneurs, it's going to be worthwhile, but when you get into these questions, often you have, gray area, but I think in that case, it probably would be allowed. I mean, because reviews are obviously one of the classic examples of fair use.
Right. Yeah, because I mean, like I listen to a lot of Christian rock podcasts where they're, they'll go in and they'll review an album and play like 30 seconds of a particular song and then comment on the song.
Yeah. And you hear that. I mean, NPR, for example, they have, a review of music, but they also probably have general licensing deals with the big companies who hold most of the copyrights. So, they might just have a license to do it. But as a general rule, a review is going to be allowed.
Yeah. Copywriting is definitely a sticky issue. I wish
the ASCAP licensing would cover podcasts. I really do.
Yeah.
Because I mean, at least ASCAP was relatively inexpensive.
Yeah. Yeah, and that's the part of the problem nowadays is if you want to license it, I mean, like you're saying, I mean, even finding who owns the publishing rights, which is the party who has the right to give you a copyright license, can be hard in certain circumstances. I have friends who are musicians who have some publishers who hold the rights to their music. So theoretically, my friends couldn't even give me the right to use the music. I'd have to go to their publisher.
Interesting. So tell me about, like, I mean, here's a question. Let's say I launch a let's say I launch a membership or a subscription model, and I'm basing it on content. Is there at any point at any point do I risk losing the intellectual property rights to that content?
Well, you would not lose copyright protection because copyright protection you get. You wouldn't lose any trademark protection. There is one area, though, where you have to be careful, and that's trade secret protection. Mm-hmm. And trade secrets, I refer to it as the Rodney Dangerfield of intellectual property. It don't get no respect. Mm-hmm. And it should, because a lot of the most valuable assets held by small companies are in fact trade secrets or could be protected that way. Mm-hmm. And people don't think about it because when you think trade secrets, the classic examples are recipes. So the Coca-Cola formula is a trade secret. The KFC spice recipe is a trade secret. But for a small business, your CRM database, your customer list, all of those things are trade secrets if you take reasonable steps to protect it. And so in your context of a membership site, it might be hard to protect it. But what you want to do is in the terms of service, have a restriction that says that, that restricts how your members can use the information.
Right.
And the classic example is if you're a coach on a particular subject, you might want to have something in your terms of service that says, hey, if you're a member of this, you can't use this information and offer a competing program. I don't know if you'd ever be able to get that enforced or if it would be worthwhile, but you should have it in your terms of service just so you have potentially the ability to do so.
That makes sense. And I know especially in the internet marketing space, piracy is rampant. Mm-hmm. There are people out there that specialize in getting a hold of people's course or property or software and redoing it and claiming it as their own. That's happened frequently in the IM space.
Well, it's interesting you say that because there is definitely examples of people taking a course and then taking the content and basically just repackaging it as their own. But one of the people who I enjoy is Amy Porterfield. She tells stories about people who they didn't even repackage it. They literally took her course, had the slides, had the videos, and just put it up with all of her logos and are selling it. That happens. But the way I like to think it, especially in that case, look, if someone's going to buy, my online course from someone who pirates it, they're going to do it because it's cheaper, right? And they never would have been my customer anyway. Right. And so it is what it is. But it definitely happens out there.
Is it worth fighting? Is it worth fighting when you find it?
That's a hard question, but candidly, probably not. And again, it depends, right? It depends on the situation. But the problem is, first of all, you have to be making enough money from the project that it's enough money if you could win everything that you lost by not making those sales. So that's the hurdle number one you have to get over. Hurdle number two, whoever you're suing has to have enough money that they could actually pay you.
Right.
And then hurdle number three is whatever money you could get from that person has to be enough to offset the amount of money you're going to have to pay to someone like me. And then also just the cost, not my fees for time, but the costs inherent in doing it. So in most cases, sadly, it's not. But what you have is potentially a different way to go about it, which is if it's being hosted, for example, on one of the major sites, like I'll just use Teachable because Teachable is somewhere that offers that you can host online courses.
Right.
If someone copied it from you, you could send what's called a DMCA takedown notice. And let me break down what that is. DMCA stands for Digital Millennium Copyright Act. And it's a law that was passed back in 1998, back when, if you think copyright infringement is rampant now, it was even worse back then. It was the Wild West. And so they were trying to get protection for copyrights online, but they also wanted to strike a balance so that the people who were hosting forums or hosting websites, they weren't liable for infringement by people using the website. And so they wanted to strike that balance. And the balance that struck is, so long as the website host or the social media host or whatever responds to, when they're notified that they're hosting infringing material, they are not liable. So companies will, if you send them what's called a DMC takedown notice, notifying them that this is an infringing course and showing them that you have the copyrighted material, they are going to take it down. And so that you'll get rid of the competition at least.
Right.
All that being said, if it's being hosted by a company outside the United States, good luck.
Yeah, that was one of the next questions I was going to ask, because I know, I mean, we're no longer in a United States only world, and you've got people in all kinds of different countries, from India to Russia to Australia, putting out content and pirating, possibly pirating content, etc. What do you do if it's someone overseas that's doing it? Do you even have any recourse?
The problem is that all these rights are territorial. So you're going to have a tough time is the answer. Especially, look, let's be honest, the people who are likely to be pirating are going to be in countries where pirating is rampant. And so, there just aren't going to be systems to enforce over there. And, look, I'll be honest, I don't know what Russia's law is on copyright infringement, or what China's law is, or any of those things.
Right.
And so it will be tough to enforce. And again, once you start having to deal with that, it starts getting much more expensive and complicated. So your business decision is often going to be, it's not worth messing with.
So you got to have somebody who's licensed to practice law there, and yeah, I could see where that could get pretty complicated.
Yeah, I can see it real muddy.
And like I said, I mean, for most cases, you're not going to be losing that much that it's worth it. So
right, that makes sense.
So let me ask you this: if you had a group of entrepreneurs, podcasters, business owners in the room, and you had just one message you wanted to give them, what would it be?
It would be the following, and it would be that you need to understand that 95% or more of the value of your business is your intellectual property. And as a result, you need to be thinking about these issues. You need to be come up with a plan for these issues. And at the same time, while 95% of the value of your company is that, 95% of the value of your competitor's company is also from intellectual property. So you need to be making sure you're not stepping on their toes. The point I would make is just to stress to people the importance of these issues to their business. And if I could give a point 1A, it would be that you can't wait. You could be making mistakes today that are effectively time bombs that will destroy your business tomorrow. And there won't be anything I can do or anyone else can do. So you can't put this issue off.
It's guys, I mean, I am certainly not a lawyer. I know marketing, that's what I do. But, this is something you gotta really have to sit down and at least consider and think about and figure out what your strategy is going to be going forward. So, I have one last question. Yep. Go ahead.
Like you said before, one sec, Trace. When your whole goal, and correct me if I'm wrong, Bobby, is to make your business bulletproof as much as possible.
Yeah, I mean it's partly about bulletproof, but it's partly just about risk avoidance. Think of these issues as avoiding risks down the line, and like I said, as lawyer repellent, so you can avoid having to deal with people like me as much as possible. And the way to do that is having a plan up front. And once it's work to put it in place, but once it's in place, a lot of this stuff can be on autopilot. I mean, you have to do a little bit of maintenance over time, but it's not like every month you have to be spending tens of hours on this.
Right. So let me ask you this. I know that a lot of people say, and I've heard a lot of people say, well, you need to have an LLC for business protection. Does that also fall in the intellectual property space? Is it better to have an LLC or some kind of corporation to protect your property?
There's not a benefit in terms of it being protectable of having an LLC. Whether you own it or your company owns it, it doesn't matter. But one of the things you need to think about is if you have a company, whether it's an LLC or something else, if you are creating stuff or created things before you started your LLC doesn't own any of that. You own it until you sign a written document transferring it. So, I mean, I have LLCs, but that's just because I have LLCs. But you do have to be careful of who owns the intellectual property if you do have an LLC and if you were creating some of it personally before you started the LLC.
I understand. Interesting.
That's a good point.
Well, with that, yeah, wow, that's definitely a lot to think about. I guess, do you have a final offer that you want to make to our audience?
Well, yeah. So I am, I'm in the process. I mean, one of the things that, so for a long time, I just had a law firm. Okay. And I offered one-on-one service to people. And the problem was I kept seeing these mistakes that had been made early on before people could justify hiring a lawyer. And, look, I'll be honest with you. If you want to hire me directly to really do work for you, it's going to cost $10,000 or more. I mean, that's just kind of the starting point for me to really dig into your business, understand everything, create a customized plan for you. And I understand for a lot of entrepreneurs, that's not doable.
Right.
So I created this other brand, Your Online Genius, and I'm in the process of putting finishing touches on a course I'm going to offer, which is going to be called Safeguard Your Online Genius, which will help people understand and do it themselves. Get some all kinds of form documents that they can use with lessons and tutorials on how to complete those documents. That's not ready yet, but right now what people can do, I've got a free cheat sheet on the 4 biggest mistakes that entrepreneurs make, and they can get their hands on that at mistakes.youronlinegenius.com. Again, that'll work.
And we will have a link to this in the show notes, guys. So that will be if you want to just go to there, you can go to sbppodcast.com. So
and just so you know, if somebody signs up for that, they're going to get the cheat sheet. It offers them a masterclass if they want to go deeper, but then they will be in an email sequence that, depending on whether they take it, when they get it, will either give them the opportunity to sign up for a VIP wait list for the course at a discounted price, or will walk them towards the process if they're listening to this way later of getting on to the Safeguard Your Online Genius course. So it'll feed them into that if that's where they would like to get ultimately.
Fantastic. And Bobby, how can people connect with you?
So the easiest way, a couple ways, you can email me. I'm bobby@youronlinegenius.com. Or you can, and that's BOBBY. You can also find me. I'm most active on Twitter personally, and I'm at Bobby Klinck, and that's KLINCK. And then I've got a Facebook page for Your Online Genius. So it's just, search Your Online Genius on Facebook, but it's facebook.com/Your Online Genius. And right now I'm doing live videos every day at noon Eastern time where I kind of give a lesson about intellectual property issues. I've kind of been doing theme weeks on different areas of platform building, so I put a lot of content out there so you can start learning. Even if you're not ready to go further than that, you can get the free content there.
Cool.
That's beautiful. Well, Bobby, it has been a pleasure. Thank you so much for coming on the show.
Thank you for having me. It has been my pleasure.
Yeah, it's been fun.
And with that, I'm Teresa.
And I'm Michael.
And you've been listening to the Small Business Puzzle Podcast. We're out.
You've been listening to the Small Business Puzzle Podcast. To catch all our past shows, visit sbppodcast.com.